Hey everyone, Rich Lowry of National Review here, and I'm joined by my colleagues, the Right Honorable Charles C.W. Cooke and Andy McCarthy, and we are a quarrelsome lot at National Review. We have internal disagreements that we will debate and discuss, usually in a civil manner. Not always, sometimes it gets intense, but we have an important but subtle disagreement between Andy and Charlie that we're going to suss out here a little bit in 15, 20 minutes, or who knows, maybe a couple hours. We'll see how it goes. But Charlie's position, in a nutshell, is that Trump does not have the legal authority on his own to strike Iran and needs to go to Congress for authorization. Andy's position is that he does have the legal authority, but should go to Congress to get authorization. So there's a difference there, which I hope all of you noticed. And if you didn't, we're going to spell it out a little bit, beginning with Andy. So, Andy, you think under Article 2 of the Constitution and based on a 2001 authorization of military force after the September 11th attacks, Trump has ample authority, if he wanted to, you're not recommending this course politically, but if he wanted to just do this on his own?
Well, I think, Rich, that the fact that, as you said at the beginning, I think he should go to Congress, even if he doesn't have to, that's really a nod to what I take to be Charlie's position, which is that if we were writing on tabula rasa, he should go to Congress. Congress has the war power. The president is not supposed to authorize war. The president is supposed to conduct war. As Oliver Wendell Holmes said, I think in the late teens or the 20s, the divisions, the boundaries between the two political branches are in shades of gray. They're not in bright lines. So it's not always easy to say where the president's power ends and where Congress's begins when we're in these types of areas. The war power is one of those areas. But I don't think that you can deny the fact that we have conducted warfare over the last 24 years pursuant to the authority of Congress. I think if there was absolutely no statute, I'd be where Charlie is. But we have an AUMF. I've been pretty adamant arguing over the last number of years that it needs to be drastically overhauled. I think it's very problematic that there's a lot that's problematic about how the AUMF was generated, beginning with the fact that in the war on terror, there was a great hesitancy, reluctance, probably worse than that, by Washington to define who the enemy was, to the point where we called it the war on terror when terrorism is actually a method. And there was great hesitation because we didn't want to be perceived as Islamophobic, which was the smear du jour at the time. So they didn't want to identify al-Qaeda. They didn't want to identify al-Qaeda's state sponsors outright. But we basically proceeded with this AUMF, which basically says that the president can authorize strikes against any person, organization, or nation that participated in some meaningful way in the 9/11 attacks. And it goes on to say that also includes harboring people who were involved in the 9/11 attacks. And then, very confusingly, and I think we discussed this in our podcast earlier in the week, Rich, it has this little thing, this coda at the end that says, in order to prevent future terrorism strikes against the United States, which there's been lots written about that particular provision of it, but it was very open-ended, and the government has regarded it as very open-ended in what it authorized the government to do post 9/11. So that's the way that we have conducted warfare since 9/11 with respect to anything that an imaginative government official could, no matter how attenuated, try to tie to 9/11. And in point of fact, if we were to say now that that AUMF is no longer operative, I've been checking what we've been doing in recent years. Even through the Biden years, we continued to attack al-Qaeda connected targets, some of which didn't even exist at the time that the AUMF was enacted, which is one of the major problems with it. We've continued to cite it, like Shabab, for example, in Somalia. There were drone strikes throughout the Biden years with respect to that entity. The reliance for it was done on the AUMF. The other thing I think we ought to note, and then I'll be quiet and let Charlie go. When Biden took office, we had about 40 people who were still detained at Guantanamo Bay but had not been charged with any war crimes. We're now down to about 16, and I think only around 6 have not been charged. But the reason this is important is under the laws and customs of war, if the war is over, you have to release anyone who hasn't been charged with a war crime. If you have people who are charged with war crimes, then you can proceed with war crimes tribunals or war crimes trials. But if you're just detaining enemy combatants and your only authority to detain them is the fact that there's a war on, you have to release them. Obviously, we've never released them. And in connection with Trump's Alien Enemies Act invocation, we've talked a lot on our podcast about the Ludecky decision, which was written by Justice Frankfurter in around 1948. And what he said basically in that case is that even though factually there was a good argument to be made that the Second World War was over, the court was not going to find that the war was over because Congress had declared war. The president had signed that declaration into law. And since it was up to the political branches to declare war, the court wasn't going to second guess them about whether the war was continuing or not. So I think it's a very tough argument to make, even though I think it's old and it needs overhauling, to say that the AUMF is not, still vibrant and vital. I'd much rather see a tailored congressional authorization that would enable strikes by Trump against Iran, but I'm not holding my breath expecting that to happen.
So, Charlie, I imagine you're going to say just because we've stretched the AUMF over the last 24 years to include groups that didn't exist when it's passed is not a reason to stretch it even further, or to put another block on top of this rickety Jenga tower in the form of a strike on a nuclear facility that also didn't exist 24 years ago and probably wasn't contemplated by anyone when they're writing this resolution.
I am going to say that, but I'm going to preface it with a related argument. In fact, I'm going to start by conceding a couple of things to Andy. The first is that if Trump hits Iran tomorrow, although I think he needs Congress to do it, it will not be out of the ordinary for modern American presidents. I presume we'll see all manner of arguments to the effect of, oh, there goes Trump breaking norms or being a tyrant. That won't be true. He will be acting in a manner that is consistent with that of President Obama and President Clinton and Reagan and LBJ and Kennedy and Harry Truman. It's ironic, actually, that the two presidents who are most associated in the public mind with foreign adventurism, the Bushes, are the ones that went to Congress in the post-World War II era. But if Trump does do this, he will not be breaking what has become a modern convention. That's the first thing I will grant Andy. And the second thing I'll grant Andy is that this area is almost certainly not justiciable, and it probably shouldn't be justiciable. I don't think you can have a Supreme Court policing this separation of powers question, at least not until it reached some extreme level. This is an intrinsically political question. If there is such a thing in our constitutional order as a political question, this is it. But I think that if the court were to look at this question through an originalist lens, I think it would find it problematic. Now, the court's not going to do that, but I'm going to do it in lieu as an American citizen. American citizens should look at constitutional questions themselves, as should the three branches. They should not be entirely reliant upon the willingness of the Supreme Court to get involved. And I think that although the history that I adumbrated is real, it is a history that has been extant since about the end of the New Deal. It really started with Harry Truman, who did not get a congressional declaration of war in Korea. And when conservatives look at the Constitution and they look at our system of government, well, we've done it since the New Deal is not usually a persuasive argument, especially when separation of powers takes a beating. Now, I would go back to the founding. This is my starting point. Before we get to the statutory question you asked about, I would go back to the founding and I would look at what we did in this country immediately after the new system was set up. You have the first Barbary War. Thomas Jefferson is president, and he goes to Congress and he says, I need a declaration of war. He gets 2, 3, 4 authorizations of military force. He doesn't get a declaration of war. But he has a line that he uses in 1802 where he says, without the sanction of Congress, to go beyond the line of defense is unauthorized. So he wants a declaration of war to fight the Barbary pirates. Then you get the War of 1812. That was declared. Then you get the Second Barbary War in 1815. James Madison, who wrote the Constitution, is president. He too thinks he needs a declaration of war. He goes to Congress and asks for it. Again, Congress says, well, I'm not doing the declaration of war, but I will give you an authorization of military force. Now, those authorizations are very specific. They do not say the president can do what he wants, or the Navy is now in the hands of the executive branch. There is some vague language in there, but they have a deliberate and explicit end. They mention, for example, the Tripolitan cruisers in the second declaration. And I think this matters because the first time America is in a position to fight, Congress is really clear about who it is fighting, why it is fighting, under what circumstances it is fighting. I think that precedent's well established, and then that precedent continues. You've got the Mexican-American War, you've got the Spanish-American War, World War I, World War II, until you get to Korea. Now, why does this matter? Andy is right when he says that the AUMF, if you squint at it, can be used to justify this war. But if a court were to look at it in the way that we normally like courts to look at things, I think they would say this is a violation of the major questions doctrine, right? This is a great Scalia line, that Congress doesn't hide elephants in mouse holes. And to get to the point at which Donald Trump, as president, is allowed to authorize an American attack on Iran, you have to find an elephant in a mouse hole. You have to say that because there was a tangential connection between Iran and those who carried out the attacks on 9/11 25 years ago, we are in the year 2025 allowed to stage a bombing run against an Iranian nuclear facility. If this were a domestic question, I think that would be a 6-3 Supreme Court decision, possibly even more. And the reason it bothers me, and I'll be quiet after I've said this, is that it strikes me that this is exactly the sort of shift in policy, not tactics, not execution, not prosecution, but in policy, that Congress exists within our constitutional system to make on the world stage. We should not have enabling acts that are on the books that can be looked at in a certain way and twisted in a certain way and then used to alter our position in the world militarily. And I agree that it's not going to yield the sort of Supreme Court decision that I've hypothesized, and I agree that this is how we've done it since the 1950s. I just don't think we should. I think it's really bad for our body politic, and I think it would be unrecognizable to the founders who behave differently.
So, Andy, a couple things. How much does what matters more, whether you can, as Charlie puts it, squint in a certain way and technically read a statute to cover a certain action, or what the drafters of that statute or resolution meant at the time? Again, I think it's very unlikely anyone was contemplating a strike on an Iranian facility of this nature, so much later, one. And two, so Iran is not going to attack us anytime soon, right? They weren't the homeland with a nuclear weapon, right? And they're not going to do it. If they were thinking about that at some point, it's been pushed out much further now because of this Iranian this Israeli strike. So how would this be stopping a terror attack on the United States the way that the original AMUF refers to?
Well, let me come back to that part because I think you're wrong about whether Iran would hit us when you consider that they usually operate through proxies, which hit us regularly, including, the Houthis, which we've been waging a pretty vicious sea war with. I want to go back to the first question. Obviously, the most important thing is always the text. And I think this Supreme Court has been very clear. This is one of the great victories, I think, in jurisprudence of Justice Scalia and Justice Thomas primarily. But we don't allow, no matter how solid we feel about it, we don't allow our intuition about what people meant when they enacted law to supersede what the text actually says. And with that in mind, I have to say, Charlie had me for as far as he went up until the elephants in the mouse hole, which I think actually is a wonderful metaphor that I agree with when I think it applies. But I think if you look at the text of this AUMF, the problem here is that it's temporally way overextended. And maybe it argues for something along the lines of, authorizations of military force ought to have like a sunset provision where you have to go back to Congress every now and then and get them reauthorized like we do with FISA. Maybe that would make more sense with an AUMF than I think it makes with FISA. But I don't see the elephant in the mouse hole thing here when you're looking at a statute that actually contemplates a tax on countries. I mean, it explicitly says that if you could tie them to 9/11, it's not just persons and organizations we're talking about, it's nations. Mm-hmm. And at the time that the AUMF was enacted, remember Bush's policy, which I actually wish Bush had stayed with, was at the time that the AUMF was basically proclaimed, we now have a message to all nations. You're either with us or you're with the terrorists. So that was explicitly directed to nation states that were sponsors of Al-Qaeda, because what we recognized at the time was that the reason Al-Qaeda was able to project power on the scale of a nation state and carry out an attack that actually killed more people than the Pearl Harbor attack was because it had the assistance of the Taliban, which in Afghanistan gave it safe haven to conduct all kinds of operations, and it had a lot of help from other nation states, including Iran. So I think if you want to make the argument that we're way overextended in time, I couldn't argue with that. I think it's true. And if you want to make the argument
that's the way it's written. It's not your fault that that's the way it's written, right?
That is the way it's not only the way it's written, Rich, it's the way it's been applied for 24 years. What we're talking about here is, let's stop the clock and go back and do it right. I'm usually okay with stopping the clock and going back and doing it right, but I would want to do it with our eyes open. We've done an awful lot of activity on behalf of American national security over the last quarter century in reliance on this antiquated AUMF, including detaining people who, if we suddenly had to release them because we wanted to say that thing was no longer in force, would be a threat to the country, which is why they've been held for as long as they've been held.
So is this thing written, let me stick with you, Andy, for a second, in such a way, let's say there's a democratic revolution in Iran tomorrow, and we wouldn't want to bomb them in that circumstance. Or maybe let's say it's a democratic country and they want to continue their nuclear program. Would this AUMF justify a strike against that government? That the nation of Iran still harbored 9/11 hijackers, and we've had some changed circumstances, but would it still apply, and we'd still be able to hit them under this?
Rich, it probably would, in the sense that a lot of sort of angels dancing on the head of a pin logic has been used to justify many of the strikes that have been that the country has relied on the AUMF to carry out. It would not at all be unprecedented to hit something that didn't exist at the time that the AUMF came out. It wouldn't be at all a change in circumstances to hit something that not only didn't exist, but was the result of very changed circumstances from the time the AUMF came out. When I wrote about this yesterday, I noted that, the purpose of the AUMF was to hit al-Qaeda, right, and wipe out al-Qaeda and its state sponsors. By the time we get to the Syrian civil war in 2013, 2014, we're using the AUMF as the justification for carrying out strikes when the people that we're hitting are people who are actually fighting al-Qaeda, and where our allies are actually, supplying al-Qaeda and fighting side by side with al-Qaeda. So I'm not making an argument for the logical sense of all this. Let me just stop by saying I think the best argument for Charlie's position and for making an exception when you're talking about using this for the purposes of warfare is something he said in his opening remarks about the two Bushes being the ones who actually went to Congress to ask for authorization. The 2001 AUMF was on the books when the war on Iraq started. And what we were told at the time of the war on Iraq was that it was a natural extension of the war on terror. So you would think that there would have been a logical reason to say that the 2001 AUMF was a perfect justification for Iraq. Yet because of the momentous nature of it, Bush felt the need to go to Congress because we're now talking about starting a war with another country. So I think, you could use that episode, I think, to say that we have a precedent on the books that says, there is a limit here. And if you're going to go to war with another country, you need to go back to Congress and get authorization. But that wouldn't change the underlying problem that literally, if we're just going to look at the text, you can use the AUMF.
So, Charlie, do you think so? Andy, not to put words in your mouth, I think basically saying that this is a little crazy, right?
Yeah.
But this is the way it's written. So, do you think Andy's legalistic matter, his legalistic reading of the statute is incorrect, or do you basically your position is it's crazy?
Well, I want to thank Andy because he made one of the points very well, better than I would have made it, that I was going to make, which is that we did go. We got a second AUMF, which implies that the first one wasn't sufficient.
Right.
I am torn on this textualist case. On the one hand, I am a textualist, and I think Andy makes a good case. On the other hand, the implications both for the statute itself and for our constitutional system of that textualist reading are absurd. For example, if it is the case that this law can be used to justify any connection whatsoever to those who helped carry out the attacks of September 11th, then there would be nothing to stop the United States, for example, bombing Britain if one of those people had lived there, or Florida, where they did live for quite a long time. And if you think that's too silly, what is to prevent that law being used in effect as an enabling act, which is itself unconstitutional? In other words, if it is the case that Congress has created this scope that can be used in all the circumstances Andy suggests, then Congress has effectively said that if the president, and remember, this is likely non-justiciable, if the president can present any connection whatsoever between 9/11 and anywhere in the world, he is allowed to take military action. In what other arena, constitutionally, would we permit that? I mean, we have just had a debate over tariffs. We have debates constantly about delegations of authority from Congress. We're probably going to get some non-delegation cases at the Supreme Court soon. And I assume that the three of us are going to be of the view that Congress can delegate some power, but that it has to have a limiting principle. If you look at the tariff cases, for example, from 100 years ago, the idea was that, and I think this is wrong, I think this is not narrow enough, but the Supreme Court's view was that the Congress can delegate the tariff power, providing there is an intelligible principle there. It can't just say, hey, Mr. President, go do what you want, because that is an intrinsically congressional authority. It's not an executive authority. So I'm torn, because I do agree with Andy that if you take a completely literalist look at the text, you can get really wherever you want to go. I also think that in any other circumstance, that would lead courts to say no, which is why I raised the major questions doctrine. And we see this all the time with, say, environmental law, where the EPA will look at a law, it will read it hyperliterally, and it will allow the federal government to do whatever it wants. And the court says, no, you're not allowed to do that, either because you're not allowed to delegate that much power, or because that is outside of the scope of that statute. Not intent, not legislative history, but the scope of the statute. And yeah, the fact that we went back a year after the first AUMF was passed and asked for a second one that explicitly mentions Iraq, and it doesn't say any other country. That one really is cabined in a way that the first one is not, should count for something.
All right, so Andy, do you want to rebut the best argument you just handed Charlie, and he just underlined there?
Well, no, I do want to say two things though. The point that Charlie makes about how disturbing it is that you could extend this outward was a problem from the get-go, and very interestingly, we see this with the left quite a bit, right? They gave Bush more power undoubtedly than they were comfortable giving him right after 9/11, but it was right after 9/11, and the opposition to the way that we were handling radical Islam was muted at that point, so he pretty much had a blank check to do whatever he wants. But what we see the left do very often is they sign off on things and then they immediately try to chop back, much of the way that they wanted to vote to approve the Iraq war, and then within 18 months or so they were anti-Iraq war. What happened in the Biden administration was they did in the administration try to tailor back the AUMF, and I think there's been a lot of sensible people, our friend Chip Roy being one of them, who have said, it's crazy to have this AUMF. We need to overhaul it to have it match modern conditions. But what Biden did was, instead of dealing with the text that allows you to hit any country or hit any person, what they wanted to fiddle with was whether something was legitimately a theater of war or not. So, for example, what Charlie mentioned about England or Florida, what Biden's people would say with respect to that is, even if somebody is cognizable as a target under the AUMF, if you're not in a theater of warfare, which I think he tried to limit at the time to Afghanistan, Syria, and maybe Iraq as well, because those cells there were a problem. That's what they end up doing. It's not that this has just gone on for 24 years and it's been problematic, but nobody's tried to do anything about it. They actually have tried to rein it in, and in part, I think that's an implicit recognition that it's not workable in terms of how it meshes with our modern conditions. The other thing I want to say, because I forgot to say it before, after Charlie went back historically, the disturbing trend from the time of those Jefferson seeking authorization for military force and the exacting nature of that has been along the lines of what I mentioned at the beginning, which is that we get so amorphous about who the enemy is. We start to say the enemy is terrorism, and who you can do almost anything with that, and we have seen abusive things done on account of it. As time has gone on, it's just these things have become worse in terms of being exacting about how and who the laws of war ought to apply against, and what the circumstances are and what the mission is, it's become more and more vaporous over time. And that's a problem because implicitly it becomes what Charlie was talking about, which is a sweeping delegation of Congress's war power to the executive, which it becomes uncheckable. And then the second thing that is so problematic is that, just to talk about the politics of this, as a practical matter, if Congress doesn't weigh in at the beginning when it's time to authorize with very firm conditions about who the enemy is and what the mission is, I think you want these to not only be preconditions to going to war, but you want them to be sensible, exacting, limiting documents. But if you don't get that, what ends up happening is we have troops in harm's way, and nobody in Congress wants to be the one who says we're going to cut off the troops because we're not happy with the mission anymore. So I think one of the things we have to bear in mind here is that if Congress doesn't weigh in at the beginning, the chance that it's going to weigh in down the road is remote.
All right, guys. Well, thanks so much for this conversation. Whatever we think, I think we can all agree there's not going to be a congressional authorization. Whether it actually needs one or just it's not going to
I don't think he cares. He doesn't care about the AUMF either. It's like Article 2, man.
Thanks so much, gentlemen.